Hello, once again, everyone. It is great to be with you on this Wednesday afternoon. Thank you for stopping by and spending a little bit of your time with us, and we hope it's worthwhile. We've got some great stuff coming for you. If you've been on the site in the past, hour or so, you can see that tomorrow's stories are already up. We're looking forward to those. Great information from Ann Llewellyn and one of her case management focus pieces. She keeps us up to speed on nurse case management and workers' comp. And this week it's a good one because it highlights the importance and the value of communication in case management to the workers' comp process. And then we have a wonderful article from one of our guest expert analysis contributors, Edward Stern, who sheds some light on the inner workings at OSHA. You hear the word OSHA and you think about the government agency behind it, and you probably have some, if you're like me at least, you have some preconceptions that have been shaped by maybe pop culture, what you hear in the media. Well, thankfully, Mr. Stern is here to shed some light on the reality behind OSHA, and I think it's an interesting one, and he has a long experience there. But those are coming up for tomorrow. What we wanted to get to was our big stories for today, and they're good ones. And one in particular, I'm particularly partial to, not just because I wrote it, but because I wrote it. I'm interested in it, and it was an interesting case that we came across. We missed it kind of when it first came out. It showed up on Simply Research. You had the full text there, but I sort of breezed past it because it was an unpublished case. And we'll go ahead and take a look at that, and we'll explain a little bit more about, for those that may not be as familiar with the legal system, why an unpublished case is one that I would ignore. All right, so we're going to go ahead and just take a look at the story based on the case. And so here's the story. The headline is "Striking Manager with Golf Cart Constitutes Assault, Not Horseplay. So saith a Virginia court." Now, like I said, this was an unpublished case. Now, when a court says it's unpublished, it's telling the legal community that it cannot be cited for binding authority. It can be cited for persuasive authority, like it makes a pretty good argument, but it's not a case that you can point to and say that's controlling law. And so when we come across those on Simply Research, we tend to put those on the back burner unless there's something interesting going on. In this case, I missed the something interesting going on until I was kicking around the site, looking up cases or statutes on horseplay across the country in a workers' comp case. Now, maybe we'll put together a PowerPoint or something on this at some point. But in a nutshell, most of the time a horseplay case is going to be one where the employer uses it as a defense, because the employee that's trying to get benefits is the one that the employer is using the horseplay defense against. And in those situations where the injured worker is the one that engaged in horseplay, oftentimes, most of the time, courts around the country will say he doesn't have a compensable claim because he was engaging in horseplay. He's goofing off. That's not part of his job. But when it's an employee who's hurt at the hands of someone else's horseplay, that oftentimes is compensable because that's the courts treat that as being tied up in sort of a workplace risk. I didn't do it. I'm just walking along minding my business, but some other coworkers, acting goofy, messing around, the kind of stuff that's typical in a workplace from time to time. Maybe it shouldn't be, as these next few examples will show you. But courts will say in that case, oh yeah, that arose out of employment, because we kind of have this category of behavior in the workplace that we call horseplay, and this person wouldn't have had that injury but for this sort of situation. And this case, by the way, it's an interesting one. The factual situation is, there's it's in the case name, so I don't think I'm sharing anything secret here. Camping World, you all know Camping World, right? Shout out to them. In fact, because I don't want them to think that we're just poo-pooing their workers, let's look at Camping World. Well, there you see. I was looking up the case and seeing if I could find this particular uh, location. I think it's this Camping World in Thornburg, Virginia, because it ends up in a Fredericksburg, Virginia court. Fredericksburg is a wonderful town, a great place. And shout out to the Cosner's Corner development there, a wonderful Publix grocery store there. Anyway, that's totally beside the point. We'll let Camping World know and I recognize that we've gone off on a tangent here, but if you're in, Thornburg, Virginia, there, go ahead and check out the Camping World store. If if that's you're getting a fifth wheel or an RV or something like that, check them out there. 6101 Mallard Road, and there's their number 888-258-5755. All right, so I've covered that. I don't want anyone to think that I'm saying anything bad about Camping World. It just so happens that's the employer in this case. Well, a manager's helping a customer out in the parking lot. I think they were, doing something or checking something out. And this coworker is, tooling around the place in a golf cart. Now, a lot of these employers that have big properties often supply their, particularly the sort of maintenance and custodial staff, golf carts to get around, clean up the place, fix things as the need arises. And that was the case here. So this worker's, like I said, tooling around in a golf cart, picking up trash, going to be taking stuff out to the garbage, cleaning the place up. Sees his manager there. I would have more questions about this, factually, about the nature of the relationship between this worker and this manager, because it sort of begs the question. But apparently they weren't really buds or anything like that. But this guy's just goofing around with the golf cart. He's got a piece of cardboard. He's going to drive up to the manager. And his plan, at least what he said his plan was, is he was going to just kind of tap him with the cardboard, and everyone has a laugh about it. And the details are a little bit sketchy here. But what ends up happening is, he's coming up with the golf cart. The manager sees him coming and sort of, freaks out and says, "Oh, hey, what are you doing? Watch out. What are you doing?" And the coworker says, well, he kind of gunned it or didn't brake in time or was going too fast or something. One way or the other, he hits him with the golf cart. The nature of, how bad the collision was is a little bit in dispute in the case, but the manager says, oh, he fell down and he crumpled on the ground. The customer says, well, he stumbled but didn't fall. Anyway, I mean, I kind of credit the customer here because he doesn't have a horse in the race. He has no skin in the game. So, I kind of see what happened. He kind of bumped him. He probably wasn't, hauling butt in the golf cart going as fast as it could, but, probably going a little too fast. You shouldn't run into people with golf carts anyway. So he runs into him, hits his knees, hits his arm kind of thing. And, that's the nature of the injury there. And the coworker says, well, listen, that was just kind of the environment we were in. We were always joking around, pranking each other, practical jokes. Regardless of that situation, the manager files a workers' comp claim. And a deputy commissioner takes up the case and said that the evidence supported a finding that the accident was a result of a personal assault, not horseplay. Essentially saying, you're barreling toward a guy that's going, hey, what are you doing, in a golf cart. That's more than just goofing around. That's, kind of what, if that happened anywhere else, if it happened in my neighborhood out here, I might be calling the cops up for assault. Anyway, so they say, all right, that's assault. It's not compensable. Well, the manager, he's trying to get a workers' compensation claim, credited here. He wants workers' comp benefits. So he appeals to the full commission. And they say, yeah, they're focused on the intent of the guy driving the golf cart and said that, well, he wasn't intending to like run this guy over. He's just, clowning around, having fun, having a laugh. That's horseplay. So, all right. Well, the Camping World, by the the way, let me highlight them again. Camping World appeals to court. That's how it works in Virginia. Appeals to court and says, wait a minute, we kind of like what the deputy commissioner said. Let's get this cleared up. So this tested the actual risk test, the actual risk rule in Virginia. And, nothing earth shattering here, but this is how Virginia courts decide whether an injury arises out of employment. And the injury must have a causal connection between the employee's injury and the conditions under which the employer requires the work to be done. So again, that gets to that issue about horseplay is kind of being like inherent in a workplace. So, that's the question here. Is that what was going on, or was it something else? And there's, you can dig into a workers' comp 101 thing that sort of brings that out a little bit. But now when we are talking about horseplay in Virginia, when horseplay among coworkers causes injury, that injury is automatically compensable under the Workers' Compensation Act. However, if it's an assault and battery, that there has to be some kind of nexus between the tort and the employment to fall within the act. So somehow that, battery had to be kind of like intrinsic to the work to get the coverage. Now, this is an interesting thing here. This case here sort of expands on the actual risk test. And here's a key point. The causative danger must be peculiar to the work and not common to the neighborhood. It must be incidental to the character of the business, and so forth. So there you go. So that'll sort of break down the causation standard involved here. And the court wants, really, is looking at this case, trying to figure it out, and calls up a few precedent cases. One is obviously this Sims case, which they say a little bit more about. But there's 3 cases here, and they're trying to figure out which one looks more like the instant case. So Hilton versus Martin. And I call these up because at least these first 2 sort of you get that, and this happens from time to time in workers' comp claims. What were they thinking? And this first one. Both of these 2 are definitely what were they thinking, and that might be that's not a legal term at all, but that might have something to do with how the court views them and in comparison to this case. Anyway. So we have this a case with EMTs basically that are on an ambulance. One of them, they had a reputation as being childish, immature, a goofball, whatever you want to call them. And he thinks it's funny, I guess, one day on the job to pick up the defibrillator paddles and come at a coworker. So he's coming at the coworker there. And she's not having it. She says, "Get those away from me," screaming at him, "Get those away from me." And, he was, okay, he's going to put him up. But then, hey, he's not done with the joke. He turns around, strikes her with him, and turns him on. Never a good idea, by the way. Well, the result was she had a seizure and then died 3 days later. So it's tragic. Now, the Virginia Supreme Court eventually got that case and said, whatever the childish guy thought he was doing doesn't matter because she experienced an assault. So the exact language was, it was immaterial whether the assailant's subjective motivation was playful, amorous, vindictive, or hostile. Whether intended as flirtatious, merely playful, or as harassment, Martin's actions were an assault. Now, the next case, and this is another one where it's like, thank God I don't work at this place. So you have they use the word pressman. I mean, even in 1995, I think that term was outdated. But guy works for the Richmond newspapers. He works for a newspaper, and he's got a boss there. And on 5 occasions, the boss, the supervisor, goosed this guy. And they explain what that means, grabbing the worker between his buttocks or genital area with an upward thrust of a finger or hand from the rear. So paints a picture for you. Now, on one of these goosing incidents, the supervisor actually achieved penetration in the goosing operation. and that triggered PTSD and depression. So again, the court says, well, uh, that was a incident of an assault. Just because it happened at work doesn't turn it into horseplay. That's the kind of thing that we say is assault. You're putting your hand up someone's private parts there. Yeah, that's assault. Now, contrast that to this guy that's, waiting tables at a Ruby Tuesday. His coworkers, they're all friends or buddies. They hang out outside of work. They start pelting him with ice. You can picture it. Young restaurant workers there. They're goofing around. Well, he tries to block himself with his arm, and in trying to protect himself from the ice, he dislocates his shoulder. Well, they say that's horseplay, and that's covered under workers' comp law. So back to this case. Here, there was another kind of influential factor in the case, and that was that the coworker, the one driving the golf cart, had a criminal case come up against him here, and he entered a no-low plea. Now, that's not the same as pleading guilty, but it's basically saying, all right, I did something wrong, and I'm going to accept the consequences that the criminal court hands down. So they're looking at this and saying, like, all right, we're already in a criminal space. If you turned around and saw someone gunning a golf cart towards you, that starts to look like an assault rather than just, if he came up and bopped him, just walking along and bopped him with cardboard. Well, that's a different story. So anyway, the long and short of it is this is an assault, and the worker doesn't have a compensable claim under Virginia's Workers' Compensation Act. So that's a kind of one of the things that's kind of case that you can find on Simply Research. And don't forget, you can get to Simply Research by going here. And if you want a free 7-day trial, you go down here, fill out the information, and get started. Now, if you already have Simply Research, you can go ahead and get going on that, and you can see what's new and see what's been added the past day or so. That summary we went ahead and put up there. We don't always put the summaries up there. There's some more cases that we might take a look at and hopefully summarize for you, and maybe we'll get some more of those presentations to get you filled in on points of workers' compensation law and how Simply Research can help you. So we hope this has been a helpful, update for you. We appreciate you spending some time with us, and look for that news tomorrow. It's going to be good stuff, and we appreciate you spending your time with us. And there's that case file on Simply Research. Thanks so much for stopping by, everyone. We hope that you have a wonderful day, and we do appreciate all that you do in the workers' compensation space. And just as a reminder, we appreciate you because it's because of you that we're able to do this. So we couldn't do it without you. We wouldn't be here without you. We appreciate you. Thanks so much and have a great day.